There was no courtroom moment, no gasp from a gallery, no scrum on the steps. The biggest privacy judgment in British legal history was published remotely on a Tuesday afternoon as a document, and the document said the same thing 97 times. Dismissed, dismissed, dismissed. Every single one of the 97 allegations that Prince Harry and his fellow claimants leveled against the publisher of the Daily Mail, thrown out by Mr Justice Nicklin of the High Court after an 11-week trial, in what the winning side is calling, with some justification, an overwhelming victory. And here is the detail that turns a legal story into the finale this series has been building toward for a month. Within the hour, the losing claimant was standing at a podium at Chatham House in London, delivering a speech about the unconquered human spirit, because the judgment landed exactly as this channel told you it would, at the precise moment his homecoming was supposed to own the cameras. The collision we predicted is no longer a prediction, it is a date stamp. 2 loops today, and both come from inside documents, which is fitting, because this has always been a series about paperwork defeating its own authors. Loop 1 is a single word, sitting quietly in the body of this judgment, a word that should worry Harry's side far more than the loss itself, because it is the only genuinely damning finding in the entire ruling, and it is not aimed at the Daily Mail. I will show you the word and who it is aimed at and why it may end an entire industry. And loop 2 is 4 words from Harry's own official response to the verdict. 4 words his team wrote deliberately, released deliberately, and apparently did not hear themselves saying, because those 4 words quietly admit something that reframes the whole £50 million catastrophe. Hold both. We close them in order. First, the ruling itself, plainly and fairly, because the scale of it deserves sober description before anyone starts celebrating or grieving. The case was filed back in October of 2022 by the Duke of Sussex alongside a remarkable roster, Baroness Doreen Lawrence, the campaigner whose son's murder changed British policing, Sir Elton John and his husband David Furnish, the actress Elizabeth Hurley, the actress Sadie Frost, and the former Member of Parliament Sir Simon Hughes. Together they accused Associated Newspapers, publisher of the Daily Mail and the Mail on Sunday, of a catalog of unlawful information gathering stretching back decades, voicemail interception, the recording of private calls, blagging of records, the use of private investigators, all of it allegedly feeding around 50 articles across the years. The trial that resulted, running from January, 11 weeks of it, is widely described as the most expensive and complex privacy case ever heard in Britain, with combined costs reported north of £50 million. And on Tuesday afternoon, Mr. Justice Nicklin dismissed all of it. Not most of it, not the weaker half. All 97 allegations, every claimant, every article gone, with the judge accepting, in case after case, the honesty of the journalists' evidence about how their stories were sourced. Now, how does a case that enormous, prepared that long, funded that lavishly, lose that completely? The answer is in the judgment's reasoning. And the reasoning is actually a beautiful piece of legal logic that every viewer of this channel should understand, because it explains not just this verdict, but half the misfires we have covered all month. The claimant's problem, the judge explained, was the difference between suspicion and proof. Their case, given the age of the allegations, depended overwhelmingly on inference. This article contained private information. The newspaper cannot now positively explain where every detail came from. Therefore, the argument ran, it must have been obtained unlawfully, and the judge rejected that chain at its middle link, in the sentence that decides the whole case. The court, he wrote, rejected the argument that simply because information was private and because Associated could not positively explain how it had been sourced, the relevant article must have been unlawfully sourced. That, he ruled, is not a permissible approach. Suspicion, even understandable suspicion, is not evidence. The claimants had to prove the unlawful act, and on allegation after allegation, they could not. He applied, too, the old and sturdy principle that the graver the accusation, the more convincing the proof must be before a court can find it established. And these accusations, dishonesty, criminality, deliberately false evidence, were as grave as civil law carries. High burden, thin evidence, 97 dismissals. Take one concrete example, because the abstractions land harder with a face on them. Among Harry's claims was an article revealing that he was to be godfather to a child of his beloved former nanny, Tiggy Leg Bork. Information so intimate, his side argued, that it could only have come from intercepted voicemail. The judge's answer is almost gentle in its devastation. Harry's evidence, he ruled, does not, without more, establish that the information was obtained through voicemail interception, still less that it was obtained by or commissioned on behalf of the newspaper. And there is the whole case in one ruling, without more. The claimants kept arriving at the courtroom door carrying the private information and the suspicion, and the law kept asking for the third thing, the actual evidence of the actual unlawful act, and the more never came. In several instances, the journalists themselves took the stand and simply explained where the story came from. A friend, an aide, a publicist, the ordinary leaky plumbing of celebrity life, and the court believed them. It turns out, and this is the uncomfortable sentence at the center of this entire verdict, that the most plausible explanation for private information reaching newspapers was never the bug in the car. It was the people around the famous talking the way people around the famous always have. One of Britain's best-known media lawyers, watching from outside the case, reached for a metaphor so perfect I am going to steal it and build this next section around it. This, he said, was always a mosaic case, little inferences from different things being assembled by the claimant's lawyers into a picture of guilt, and the defense lawyers, he said, cleverly rearranged the same tiles to show an innocent picture instead. That is exactly what an inference case is, a mosaic, and it explains the single most important piece of context that the gloating coverage is burying today. So let me put it front and center. Because fairness is the entire currency of this channel. This was not Prince Harry's first newspaper war. It was his third, and he won the first two. Against the publisher of the Mirror, he took a case to full judgment and prevailed, with a court finding of widespread and habitual unlawful news gathering, a genuine, historic, undiluted victory. Against the publisher of The Sun, he extracted an unprecedented public apology and substantial damages in settlement, an outcome its recipients had sought for decades. 2 wins, now 1 loss. That is the honest scoreboard, and anyone telling you today that the entire press campaign was always a fantasy is spinning you exactly as hard as anyone who tells you this loss is a technicality. The truth is more interesting than either camp's version. His winning cases had the more: admissions, documents, proof you could hold in your hand. Evidence that led a court or force a settlement to complete the mosaic beyond argument. This case had suspicion, inference, and 1 witness, which brings us to the witness, because the story of how this £50 million cathedral lost its foundation stone is the most extraordinary subplot of the entire trial, and most of today's coverage has skipped it. His name is Gavin Burrows, a former private investigator, and in the beginning, he was the case. Back in 2021, a witness statement bearing his name was provided to the claimant's side, and it was dynamite, describing, in effect, a commissioned campaign of interception and blagging carried out for the Mail on Sunday, hundreds of instances across the early 2000s. On that foundation, in large part, the cathedral went up, the filing, the publicity, the roster of famous claimants. And then, somewhere on the road to trial, the foundation stood up and walked to the other side of the courtroom. By the time the case was heard, Burrows was testifying for the newspaper, calling the contents of that original statement absolutely incorrect, and claiming the signature on it was not even genuinely his. The judge, weighing the wreckage, found that Burrows did not give credible evidence of involvement in the disputed articles and declined to accept the 2021 statement as reliable at all, ruling it was not even proven to have been produced by him. Absorb what that means. The Star document of the claimant's case ended the trial as an exhibit of uncertain authorship, disowned by its supposed author, who was now a defense witness. Cases have survived bad days in court. No case survives its cornerstone switching teams. And the professional question that hangs over this entire enterprise, the question the cost judge may soon be asking with 50 million pounds of consequence attached, is who checked? Who, in the 4 years between that statement and this verdict, pressure tested the foundation before building a cathedral of celebrity claimants on top of it? Because somebody billed a great many hours and the checking on the evidence of Tuesday never happened. And then there is the thread everyone watching this trial in January could not look away from. And I am going to handle it with a precision the coverage has largely abandoned, because this is where commentary either keeps its discipline or becomes the thing it criticizes. During the trial, Harry's evidence included the assertion that his social circle did not leak, that he did not consort with journalists, and, specifically, that he did not really know the Mail on Sunday's editor-at-large, a journalist named Charlotte Griffiths. In response, the newspaper's lawyers produced messages. Private, friendly, years-old messages between Harry and Griffiths from 2011 and 2012, in which he introduces himself as H, is greeted by her as Mr. Mischief, a nickname the exchange shows he recognized, calls her Griff, laments missing what he calls their movie snuggles, teases her about whether she ever works, and signs off with the easy warmth of, at minimum, a genuine social friendship. She had never made those messages public in all the years she was mocked for claiming to know him. She produced them only when his case put her honesty in issue. Now, here is what those messages are, and here is what they are not, and the difference matters enormously. What they are is devastating to his credibility as a witness. A man who testified that his circle was not leaky and that he did not know this journalist was confronted with warm, familiar, nickname-laden correspondence with that exact journalist, and every assessment of his evidence afterward carried that shadow. What they are not, and listen carefully, because half the commentary today is asserting otherwise at the top of its voice, is a finding of perjury. No such finding exists anywhere in this judgment. Contradiction between testimony and documents can mean many things. Failed memory across 15 years, motivated forgetting, careless absolutism under oath, and yes, in some cases, lying. But which of those it was is a determination only a court can make. No court has made it, and I am not going to pretend otherwise for the sake of a thumbnail. The messages cost him the trial's credibility contest. That is documented, that is fair comment, and that is where the honest version of this story stops. Because, and here is the twist that almost nobody reporting this today seems to have read far enough to find, there is a dishonesty finding in this judgment. Exactly one. And it is my loop number one, and it is not aimed at Prince Harry, and it is not aimed at the Daily Mail. It is aimed at the lawyers. Buried in the judgment, Mr. Justice Nicklin made a finding of dishonesty over the way the claimant's own legal team placed stories on a campaigning website in order to artificially create what the law calls watershed moments. Let me translate that out of legalese, because it deserves plain English. Privacy claims in Britain carry a 6-year time limit, and these allegations stretched back decades, so the claimants needed to argue that the clock only started recently, at the moment they first discovered the alleged wrongdoing, their watershed. And the judge found that stories had been planted by the claimant's side on a friendly investigative website, precisely so those publications could later be pointed to as the discovery moments that restarted the clock, manufactured watersheds. A dishonesty finding from a high court judge against the machinery of the claim itself. Now think about what that single word does, because its blast radius extends far beyond this case. The entire modern industry of celebrity press litigation, the roster model, the same counsel, the same funders, the same website ecosystem, the same procession of famous claimants that has marched through the courts for a decade rests on the credibility of exactly that machinery. A judicial finding that the machinery manufactured evidence of timing is not a lost case. It is a wound to the business model. The Daily Mail walked out of this trial cleared. The claimants walked out defeated. But the only party that walked out with an actual finding of dishonesty attached to its conduct was the side that came to court accusing everyone else of it. And if you think the costs arguments The regulators and every defense lawyer in the next case will not be reading that paragraph aloud for years. You have never met a lawyer. That is loop 1, closed. And notice the shape of it one more time, because it is the shape of this entire series. The campaign built to expose wrongdoing was the only place the judge found any. Pull the camera back one final click, because Tuesday may be remembered as more than one man's defeat. It may be remembered as the closing of an era. For a generation, British public life has been shaped by the fallout of the industrial phone interception scandals of the early 2000s, the convictions, the closures, the great public inquiry into press conduct, and the long campaign to bring newspapers under statutory regulation. That era produced real victims, real jail sentences, and real reform, and it also produced a durable litigation economy, the standing machinery of claimant firms, campaign groups, friendly websites, and celebrity rosters that has cycled through the courts ever since, treating every publisher as the next domino. Tuesday was that machinery's maximum effort, its most famous claimant, its most expensive trial, its most ambitious target, the biggest beast in Fleet Street, and the machinery did not merely lose. It was found, in one respect, to have manufactured its own evidence of timing. Reasonable people can hold two thoughts at once here, and I do. The old abuses were real, the reckoning was earned, and the era in which every private detail in a newspaper could be presumed stolen is now, as a matter of law, over. Courts will demand proof, not vibes, and publishers who kept their notebooks for 20 years will be believed when the notebooks back them. Whatever you think of the Daily Mail, and this channel has never carried water for any newspaper, a press that can be bankrupted by inference is not a free press, and a judgment insisting on evidence protects the honest journalist and the honest claimant alike. The curtain, in other words, did not just fall on Prince Harry on Tuesday. It fell on the last act of a 20-year war, and the final scene, no dramatist would dare invent, was the era's loudest crusader losing to his mother's favorite paper. The victors, meanwhile, did not do magnanimity, and I will report their statements fairly because they are part of the record, while noting exactly what they are, which is triumphalism with a press office. Associated newspapers called the judgment an overwhelming victory for the Daily Mail, its journalists, and a free press generally, noted that every single one of the 97 allegations was dismissed, and the honesty of its journalists accepted in every case, described the original claims, the bugs in cars, the intercepted calls, the accessed bank accounts as lurid and preposterous, a fishing expedition in a politically motivated campaign to muzzle the press, and announced, with relish you could hear through the page, that it will now pursue recovery of the costs it incurred, costs sitting inside that £50 million total that somebody must now pay. And then came the personal statement from Paul Dacre, the legendary and ferocious editor-in-chief, a man who has clearly waited years to write it. He called Harry a confused and angry young man he felt sorry for, mocked the memoir and its parade of self-exposures, the substances, the romantic initiation, the combat record, and delivered the line that will be quoted for a decade, that there is not a laundry in the cosmos big enough to wash all the dirty linen. Harry has aired about his own family, and that for him to complain of invaded privacy takes not just the biscuit, but the whole tin. He framed the entire action as a conspiracy supported by the press regulation campaign lobby to destroy a newspaper and revive statutory control of the media. That last part is Dacre's assertion, not a court's, and I label it accordingly. But the passage in his statement that genuinely stopped me was not the invective, it was the history. Because Dacre reminded the world of something Harry's own mythology cannot absorb, that Princess Diana liked the Mail. That it was, in her wars, her paper, taking her side in the breakup. That she spoke and met with Dacre himself, and that the Mail's veteran royal writer was her actual friend and confidant. Harry has framed his entire press crusade as his mother's unfinished work. The man he just lost to spent Tuesday evening explaining, plausibly, that his mother was on the other side. And Harry's own response? It came jointly with Baroness Lawrence's dignified brief, and it contained my loop number 2, so read it with me carefully. The verdict, they said, was a complete and obvious whitewash. They came to court, they said, seeking justice and accountability, and 4 words, it was not altogether unexpected. There they are, not altogether unexpected. Now, the whitewash line first because fairness demands it be weighed and not just quoted. It is the claimant's right to believe the court got it wrong, and the judgment itself acknowledges their suspicion was in places understandable, merely unproven. But whitewash is a specific accusation. It says the tribunal, not the evidence, failed. And having read the reasoning, the meticulous allegation by allegation reasoning, I find that charge impossible to sustain and, franker, still revealing. Because this is the pattern this series has documented 7 episodes running. The committee that says no is biased. The palace that says no is plotting. The court that says no is whitewashing. Every institution that declines this operation's claims is, in the operation's telling, corrupt. And at some point, the simpler explanation, available to everyone else, knocks politely at the door. But it is the 4 quiet words that matter more. Not altogether unexpected. His own statement, drafted by his own team, concedes that the losing side saw this coming. And that concession detonates the £50 million question that no friendly outlet will ask him. If the defeat was not altogether unexpected, if his own camp could read the mosaic falling apart, the cornerstone witness defecting, the messages landing, then the decision to press on to judgment rather than settle was made with open eyes at staggering cost against visible odds. You do not do that for damages. You do not even do that for privacy. You do that when the case has stopped being litigation and become identity, when losing in court feels survivable but stopping feels like dying. 4 words and they explain the whole cathedral. He knew, and he could not stop. That is loop 2, closed. Now, the collision, because this series earned this section and I intend to collect. 3 episodes ago, when the visit was still a rumor of itineraries, I told you that the High Court had listed this judgment for the exact window of Harry's return, and that whatever the result, his homecoming could never be the controlled, single message moment it was designed as. That even his best case had an asterisk built in. On Tuesday, the asterisk became the headline. The judgment was released, remotely, in the very hour Harry was due at Chatham House, the Grand Institute on St. James's Square, for an Invictus Games Foundation conversation ahead of the Birmingham countdown. Under British practice, parties learned the result shortly before publication, which means he received the news, all 97 dismissals of it, somewhere in private accommodation, the palace rooms having evaporated exactly as we chronicled, and then had to get into the car, ride through London, walk into that building, and deliver a speech about resilience. And he did deliver it. Different nations, different militaries, different approaches to recovery, and what brings us together, he told the room, is more important than what sets us apart, closing on the belief that the unconquered spirit exists in every nation. Watch the footage yourself and draw your own conclusions about the man delivering it. I will only report what the cameras show, a quiet arrival, a subdued room, and, on the pavements outside, the detail this series predicted in the polling episode, and takes no joy in confirming. No crowds, not protesters, not hecklers. The worst thing, nobody much at all. The verdict of the tracker, made flesh on a London street, a Range Rover arriving unbooed and unwaved at, while inside, a man who had prepared, according to the ecosystem around the case, for the possibility of standing on that stage as the dragon slayer who felled Fleet Street, instead read a speech about spirit remaining unconquered. On the afternoon, his own had taken the worst blow of its litigating life. Even his fiercest critics might have allowed him a private day. The calendar, which his own lawsuit built, did not. And the courtroom that produced Tuesday's judgment had already given us, months ago, the vignette that explains it. One small exchange from the trial that I keep returning to because it contains the entire saga in miniature. Harry, in the witness box, was doing what the judge himself gently observed many litigants do, arguing back at the defense barrister, contesting every framing, treating cross-examination as combat, and Mr Justice Nicklin, the man who would decide his case, leaned in to help him, explaining that it was counsel's job to put allegations that Harry did not carry the burden of arguing the case from the box, that he could simply say, "I do not accept that." And when Harry replied that he had had a bad experience with a previous barrister, the judge answered, with a patience you can hear in the transcript, "I am intent on you not having a bad experience with me, but it is my job to ask you these questions." Read that exchange twice. The most senior judge in the case, offering the claimant a lifeline of procedure and calm, and the claimant unable to take it because he could no longer distinguish between a question and an attack. That is not a legal failure. That is the operating system this series has documented for 7 episodes. The settled conviction that every institution is an ambush, displayed to the one institution that was visibly, on the record, trying to be fair to him. The Mosaic case failed for lack of evidence. The witness failed for the same reason every venture around this man now fails, because somewhere along the road, suspicion stopped being something he felt and became something he is. Meanwhile, the backdrop to verdict day was the palace story we covered in the last episode, now splashed across every front page in the country. The sun on the king's patience snapping, the Express on Harry turned away, the Telegraph, the establishment's own broadsheet, on the king putting his foot down, and the briefing behind them all, from a royal aide, in language colder than any statement this reign has produced. The king wants to be a loving father and grandfather, but that was being tested beyond endurance. He is not willing to be pushed around, nor to indulge a constant state of chaos, tested beyond endurance. Bank that phrase, because palace sources do not reach for it casually, and note what the aide confirmed alongside it, that the collapse of the palace stay followed a Friday deadline and a month of indecision, precisely the chronology this series reconstructed before the briefings confirmed it. And yet, on the very afternoon of the verdict, sources close to Harry were still telling the Mail, of all papers, on the day it beat him in court, that he remains keen to see his father this week and is looking forward to spending time with the king. The request survives everything: the file, the deal, the deadline, the verdict. Whatever else collapses, the child's ask endures under the rubble, and I confess that of every detail in this brutal week, that one is the hardest to mock, because the children are still in this story, and the reporting around them on verdict day was the week's quiet heartbreak. Sources close to Harry told the Mail that he remains really keen to bring Archie and Lilibet, that he wants to ground them in their British heritage, that their lack of knowledge of the country and connection to it is becoming apparent, that they need to see their grandfather and understand where they come from. And then a friend added the detail that stops the whole circus cold. The children were told about this trip some time ago. They have been talking about it for months. They are, in the friend's words, beside themselves, hopping up and down with excitement, and Harry does not want to disappoint them. Read that against everything this series has established and feel the weight of it. The security was refused months ago, and every adult in that household knew the terms. The palace stay died by deadline. The visit has been on again and off again through 4 separate news cycles. And through all of it, 2 small children in Montecito have been counting sleeps toward a promised adventure that the adults promising it had not secured and, on the evidence of this month, could not secure. I will not tell you what that means about anyone's heart, because I cannot see hearts. I will tell you what every parent watching already knows, that you do not tell children about the trip until the trip is real, precisely because their hope is not a resource, and that whatever the strategic explanation for announcing it to them early, the people who will pay for this month of adult chaos in the currency of a crushed small hope had no vote in any of it. One veteran royal author put the long view bleakly this week, that these children will grow up having never really known either grandfather, and that when they are old enough to understand why, and to read the archives of exactly how it happened, the reckoning will not fall where their parents expect. That is not commentary I enjoy passing on. It has the ring of prophecy about it all the same. Then there is Invictus, the flag under which this whole ruinous week officially sailed, and the question now being asked out loud that was unthinkable 5 years ago. Whether the founder has become the foundation's biggest liability, the pattern of the week wrote the case by itself. An Invictus countdown visit that generated, by my count, 0 days of coverage about veterans and wall-to-wall coverage about security files, palace doors, and courtroom defeats. A Chatham House event for the foundation remembered solely as the stage on which its founder absorbed a legal catastrophe. And, per the reporting we examined in the polling episode, a palace strategy already visibly separating the cause from the man, warm words for the games. For Birmingham, for the competitors, and institutional silence around their patron. Into that context this week came a suggestion from one of the most establishment-friendly commentators alive, a royal author of decades standing, and it landed like a thunderclap precisely because of its gentleness. Harry, he suggested, might now do the Invictus Games an enormous service by stepping down, letting them take a different patron, fund themselves, and get on with the work, free of the controversy that now attends his every appearance. Think about the journey of that sentence. The games are the best thing Harry ever built, the genuine article, the one achievement, even his harshest critics salute, and the kindest voices in royal commentary are now saying, out loud, that the finest service the founder could render his own creation is to leave it. There are also, I should note for completeness, swirling questions in parts of the commentary world about the game's funding picture ahead of Birmingham, claims of government money committed and private fundraising lagging, which I pass along strictly as unverified commentary rather than established fact. But the funding question, true or not, is downstream of the reputational one, and the reputational one was answered this week in the cruelest possible way, by demonstration. Sponsors do not flee causes, they flee chaos. And for 7 straight days, the cause and the chaos shared a lanyard, which leaves the money and the end game. So let us do the sums. The celebratory coverage will not. £50 million and more in combined costs, under a system where the loser ordinarily pays the winner's bill, with the victorious publisher already announcing it will pursue recovery. Reports around the case suggest litigation insurance covers some of the claimant's exposure, and commentary suggests the wealthiest names on the claim may shoulder outsized shares. But whichever way the cost judge eventually slices it, the arithmetic of Harry's decade against the press now reads as follows: 1 historic win against the Mirror, 1 landmark apology and settlement from the Sunday, and 1 scorched earth defeat to the Mail, carrying the biggest bill of the 3, arriving in the same season as the failed security campaign, the collapsed palace stay, and the lowest polling either Sussex has ever recorded. Even his victories, remember, were financed against future earnings that the polling episode showed are narrowing by the quarter. This is what the end game of litigation as identity looks like. Not a single dramatic bankruptcy, but a slow arithmetic in which every fight costs more than the last, wins less than the last, and is announced to a country that has increasingly stopped listening. And so, inevitably, verdict day produced the demand, roared from the excitable corners of the commentary world within minutes of the judgment: strip his titles, lock the palace forever. Formal, final legislative exile. And because this channel finishes its arguments, let us take the demand seriously enough to examine it, and then let us decline it, for reasons colder than mercy. The constitutional reality first. Removing a dukedom requires, in practice, an act of parliament machinery so heavy it has been seriously contemplated only for treason and its neighbors, and the recent precedent of Andrew, whose titles were dismantled, involved association with the gravest scandal of the age, not lost lawsuits and leaked files. Nothing in this week's judgment, which, remember, found no dishonesty by Harry himself, comes within a mile of that threshold. But the better argument against the demand is strategic, and it is the containment doctrine this series laid out 2 episodes ago. A stripped, exiled, formally cast out Harry is a martyr with a memoir, handed the only thing his narrative currently lacks, which is proof of the persecution he has alleged all along. The institution's actual play, visible all week, is crueler and wiser. No stripping, no banning, no drama. Just a full diary, a closed door, a liaison officer's phone number, and the slow, silent operation of consequence, in which nothing is ever taken from him and everything is simply, politely, no longer offered. You do not fight a victim narrative with punishment. You fight it with paperwork and patience. And on Tuesday, the paperwork won by 97-0. So, the ledger and the loops closed in order one last time this season. Loop 1, the word, dishonesty. The only such finding in this entire judgment aimed not at the cleared newspaper, not at the defeated prince, but at the conduct of the claimant's own legal machinery over watershed moments manufactured to beat the clock. The campaign that came to expose wrongdoing ends as the only party found to have committed any, and that paragraph will outlive every headline written today. Loop 2, the 4 words, not altogether unexpected. His own statement, conceding his own side, saw the defeat coming, which converts the decision to fight on from misfortune into choice, a £50 million choice made with open eyes, because the case had long since stopped being about articles and become the last remaining structure of an identity. He knew he could not stop. Everything else this month, the file, the deal, the deadline, the door, is that sentence wearing different costumes. And the resolution of the season, because this series has been one continuous argument, and Tuesday was its proof. 7 episodes ago, I told you that this operation's most dangerous enemy has never been the palace, the press, or the public, but its own paperwork, and look now at the full exhibit list. A security file that discredited itself by its provenance, a peace deal broken by its own announcement, a withdrawal accusation refuted by its own timeline, a response statement confessing its own foresight. And now a judgment in which the only manufactured evidence belonged to the accusers. No conspiracy did this. No courtier, no committee, no editor. A man built a machine to fight his family and his country's institutions, and the machine, faithful to the end, fought them all the way down, through every committee, every deadline, every courtroom, until on a single Tuesday afternoon, it finally ran out of institutions to lose to, and its owner stood at a podium in the country he cannot stop returning to, telling a quiet room that the human spirit remains unconquered. And the terrible, tender truth underneath this entire season is that the speech was accidentally honest. Something in him is unconquered. It is the part that keeps knocking on every door in Britain long after learning what the answers will be. The doors are not the tragedy, the knocking is. What remains of the visit now plays out in days. The Birmingham countdown, the question of the king, the question of the children, the question of Althorpe, and I will be with you for every frame of it. But mark Tuesday in your calendar of this saga, because seasons of stories have finales, and this was it. The paperwork era is over. Everything after this is aftermath. And aftermath, as this family knows better than any on earth, is where the real story always begins. Stay close.